Okay, this last one more we will see. Okay, explain the provisions for cultivation of uncultivated land under Karnataka Land Reforms Act 1961. Okay, so chapter 6, sections 84 to 88 of Karnataka Land Reforms Act, it makes provisions for cultivation of uncultivated land. Okay, so uncultivated land may be required to be cultivated, section 84. If the Assistant Commissioner is satisfied that any area has remained uncultivated for a period of not less than 2 consecutive years without sufficient cause, he may serve notice to the landowner to cultivate the land within 1 year from the date of service of such notice. Okay, because we are, like it should not happen that this lands are simply lying there, people are not cultivating, they are saying that it is an agricultural land, they are getting some exemptions and stuff also. Okay, and what they are doing is simply land is lying like that, they are not cultivating anything. That should not happen. Okay, so uncultivated land may be required to be cultivated. Maybe you are having an agricultural land which is for the purpose of cultivation, but you are not cultivating. Okay, their cultivation might be required based on notice given by Assistant Commissioner. So Assistant Commissioner might say that for the last 2 years, okay, 2 continuous years, you have not cultivated anything in this plot of land. So cultivate something in this plot of land within the next 1 year from date of service of this notice. Okay, so uncultivated land may be required to be cultivated based on notice given by the Assistant Commissioner within 1 year from date of service of such notice. It has to be cultivated. Power of Assistant Commissioner to lease out uncultivated land, section 84. Okay, if such uncultivated land is not cultivated, first of all, it was not cultivated for 2 consecutive years, Assistant Commissioner gave a notice. Even after that notice, within 1 year from the date of service of the notice, it was not cultivated. Okay, so in such cases, what will happen is the Assistant Commissioner may, after making proper inquiry, Assistant Commissioner will inquire if there might be some reasonable cause also, or maybe they have received some false information, actually cultivation was done, right? After making proper inquiry, Assistant Commissioner may lease out the whole or part of such uncultivated land and any such suitable lessee for a period not exceeding 5 years on the condition that lessee shall pay such reasonable rent to the Assistant Commissioner, may fix, or on such other terms can be secured. So if Assistant Commissioner, after making inquiry, he is satisfied that this person is simply not cultivating anything and he is simply keeping the land, then Assistant Commissioner might give it on lease also to some person. Okay, for a period not exceeding 5 years, lesser than 5 years, for any duration, Assistant Commissioner may give it on lease to someone who is interested to cultivate, and this person will have to pay some amount of rent to the Assistant Commissioner as well. That also will be fixed by the Assistant Commissioner. Okay, is it clear?
Yes, ma'am. Yeah.
Cancellation of the lease, section 86. Even when any uncultivated land is leased out, the Assistant Commissioner is empowered to cancel the lease in case of default from the lessee and grant a fresh lease to any other person on such terms and conditions as he thinks fit. Now, first of all, there was owner of an agricultural land. He was not cultivating anything for 2 consecutive years. Assistant Commissioner gave him a notice that you cultivate something within 1 year. The person did not do it. So Assistant Commissioner gave it on lease to someone on a condition that you need to pay monthly or some rent amount you need to pay. Okay, and this lease was for lesser than 5 years. But this lessee failed to pay the rent. Okay, so the main purpose of giving it on rent lease was to get some amount of rent, right? If there is default from this person wherein he failed to pay the rent, in such cases, Assistant Commissioner is empowered to cancel this lease also. Assistant Commissioner may cancel this lease and give it on lease to somebody else. A fresh lease may be issued to some other person, and assistant commissioner only will fix terms and conditions, whatever he thinks fit. The person whose lease is cancelled by assistant commissioners shall forfeit all rights under his lease and shall also be liable to pay such sum by way of damages as may be decided by the assistant commissioner in each case. So assistant commissioner might say that, okay, this much is pending rent which you need to pay. Along with it, you need to pay some compensation because of waste of time, because of waste of resources, whatever. Right? Whatever amount assistant commissioner fixes, that also should be paid by the person. And whatever rights he had got previously under the lease, all of that is going to come to an end. The sum so determined as damages shall be recoverable as arrears of land revenue. So from this person, that amount will be collected by the assistant commissioner. Okay, execution of lease, liability of landowners, etc. Section 87. Leases on uncultivated land must be executed by the assistant commissioner on behalf of landowner or other person who is entitled to be in possession of the land. The lessee shall be liable to pay rent specified in the lease to the person on whose behalf lease was executed at the time and in the manner provided for this lease. So this land owner is having the rights or liabilities that uncultivated land will be given on lease by assistant commissioner, and assistant commissioner is going to execute it on behalf of such landowners. Okay, assistant commissioner is only fixing terms, conditions, ensuring that lease is being fulfilled. If not, he can cancel it out also. He can make a fresh lease also. All of that assistant commissioner is going to execute it. The landowner or other person on whose behalf the land is leased out to the assistant commissioner shall, in respect of services rendered by the state government under this chapter, be liable to pay to the state government a sum equal to 4 times of the land revenue payable on the land, and the said sum shall be recoverable as areas of land revenue. Now this landowner is there, on his behalf assistant commissioner is executing the lease, right? So what he has to do is he will have to pay to the state government a sum equal to 4 times the land revenue. That amount has to be paid to the state government by this person, because on his land, on behalf of him, assistant commissioner is leasing it, assistant commissioner is doing all of that. So this person needs to make a payment to the government which is equal to 4 times the land revenue. Every lease executed by assistant commissioner under this chapter shall be valid and take effect according to its terms. So it's not that somebody else is doing it, owner has not done, assistant commissioner has done, so it's not valid or something. That's not going to apply. This lease is going to be valid, effective, and binding, even though it is done by the assistant commissioner and not by the owner. Last provision is section 88, delivery of possession after the period of lease. So after the expiry of period of lease granted under this chapter, assistant commissioner shall take over possession of the land and deliver possession to the person entitled. So the person is going, assistant commissioner will say that, okay, this lease was given for 3 years. Now 3 years is over. Give it back to me, and he will give it back to the landlord or whoever is having rights at that point. It will be given to this person. Okay, is it clear?
Yes, ma'am.